Welcome back, Metis 2026 batch. Can the Supreme Court strike down something that society strongly supports? That single question is the battlefield of constitutional morality. Now, listen carefully. For the Prelims 2026, UPSC is not simply testing whether you know articles or not, it is testing whether you understand the ethical logic that guides constitutional governance, and that is where most aspirants make a mistake. Many aspirants memorize articles, judgments, and definitions, but they fail to understand what principle actually guides the Supreme Court. When the Constitution becomes morally silent, when the Constitution becomes morally silent, what principle actually guides the Supreme Court when the Constitution becomes morally silent? They fail to understand this thing. And this is why constitutional morality becomes extremely important. Because in modern governance, the conflict is no longer only legal versus illegal. Now, the conflict is often constitutional versus popular, not only legal versus illegal in the modern governance. Very important distinction. You have already seen this doctrine in Sabarimala case and Navtej Johar case and Manoj Narula case, Manoj Narula case. But here comes the real Metis challenge is, can you distinguish between societal morality and constitutional morality? Because if you cannot distinguish these two, what is societal morality and constitutional morality, and distinguish these both, if we cannot distinguish these two, UPSC can easily trap you in elimination. And remember this line very carefully. UPSC does not test whether you know judgments or not. It tests whether you can detect the wrong moral framework under pressure. Let us decode this system step by step. And one more thing you have to remember carefully in this exam hall. In the exam hall, UPSC will not ask define constitutional morality. It will ask like this. It will give morality, traditions, public order, dignity, all these in inside one statement cluster. So, and you must detect which moral framework is operating. That is what you have to do in the examination. That is what you have to eliminate in the statement cluster. Then you have to retrieve the correct answer. So, first of all, let us understand the historical DNA of constitutional morality. What is the history of constitutional morality? The term itself was originally used by the British historian George Grote in 1846. What he is defined, he defined it as a paramount reverence for the forms of the Constitution. He defined it as a paramount reverence for the forms of the Constitution. Now, for UPSC, this is background knowledge. The real anchor is Dr. B.R. Ambedkar. Inside the Constituent Assembly, Ambedkar gave one of the most important warnings for Indian democracy. We have to look what he said. He said like this: democracy in India is only a top dressing on an undemocratic soil. Let me repeat it again. What he said: democracy in India is only a top dressing on an undemocratic soil. What did Ambedkar actually mean this? A constitution alone cannot save a republic. Why? You may ask you, like, why? Because even the best constitution can fail if institutions stop respecting restraint. So Ambedkar argued that democracy requires constitutional discipline, institutional restraint, respect for procedures, and respect for boundaries. This is constitutional morality. These things has to be developed for the institutions. Very important UPSC clarification here is constitutional morality does not mean judges making random moral decision, does not mean personal morality, does not mean emotional activism. No, this is not. Ambedkar's original vision was about institutional propriety. Institutional propriety. What is the meaning of institutional propriety here? The executive must respect limits. The legislature must respect constitutional values. And the judiciary must respect the separation of powers. Every institution must remain inside its constitutional boundary. And this becomes extremely important for modern governance. Because today, constitutional crises rarely happen through military coups. They happen through misuse of institutions. They happen through procedural manipulations. They happen through silent erosion of conventions. With all these type of issues, constitutional crisis will have constitutional crisis happen, and constitutional morality acts as the invisible stabilizer of the republic. And constitutional morality acts as the invisible stabilizer of the republic. In the exam hall, UPSC will not going to ask define constitutional morality. It will ask morality, traditions, public order, dignity, like this inside one statement cluster. And you must detect which moral framework is operating behind this. We are moving to the modern judicial revival. Now comes the most important evolution here is how did a 19th century political idea become a modern judicial doctrine inside India? This happened through that what we call judicial revival. Over the last decade, the Supreme Court increasingly started using constitutional morality. Why? To interpret the spirit behind the Constitution, not merely the literal wording. And this distinction is extremely important for 2026. Why? Because modern UPSC questions are increasingly testing text versus spirit. Notice this shift very carefully. Earlier, constitutional morality was about institutional restraint, but now it is increasingly becoming a tool for protecting dignity. Now, let us see the major cases here. We will discuss two to three questions, two to three major cases here. And the first one is Manoj Narula versus Union of India case in 2014. The issue was here, can ministers with criminal antecedents be appointed? This is the issue. Now, technically, the constitution did not explicitly prohibit such appointments, but the Supreme Court argued that even if something is technically legal, high constitutional office must still maintain ethical legitimacy. The very important phrase here is institutional duty. The court said the prime minister and chief ministers must uphold constitutional morality while selecting the ministers. This is all about Manoj Narula versus Union of India case. And we are moving to the next case, that is the major case Sabarimala judgment 2018. What is Sabarimala judgment 2018? What is the judgment? This is extremely important for elimination logic. The court held that constitutional morality must prevail over social morality. The court held that constitutional morality must prevail over social morality. This is one of the most important distinctions for prelims 2026. What is the social morality here? Social morality means prevailing social traditions. Social morality means community beliefs. Social morality means majoritarian customs. But the constitutional morality means dignity, liberty, equality, and individual rights. This is all comes under constitutional morality. This means even if a society supports discrimination, the constitution may still reject it. If society supports discrimination, the constitution may still reject it. Means religious freedom is subjected to constitutional limitations. And this exact logic appears again in Navtej Johar case. The Supreme Court treated the Constitution as a living document. What is the meaning of living document? The moral reasoning of constitutional democracy evolves with time. The constitution survives not through frozen text, but through evolving constitutional interpretation. It actuates when legality becomes morally insufficient. It actuates when legality becomes morally insufficient. That line captures the entire doctrine. In the exam hall, UPSC will not ask like this. UPSC will ask another way. And we are going to discuss about the traps which will UPSC put in the examination. Now comes the most important section for May 2024. That is the traps. Because UPSC will not ask this topic directly like a school exam. It will attack through a small wording distortions. It will attack through conceptual confusion. It will attack through elimination of deadlocks. It will attack through these distortions, confusions, and deadlocks. So let us decode the major traps here. We are classified few traps here. Let we discuss one by one. The first and foremost trap is the trap number one, that is the societal trap. UPSC may give you like this sentence, like UPSC claim like this: constitutional morality is based on prevailing traditional values. UPSC may statement give like this. What is the statement? Constitutional morality is based on prevailing traditional values. Statement correct or wrong? This is the wrong statement. In many cases, constitutional morality actually protects individuals from traditional social pressure. This is why the doctrine is often counter majoritarian. What is the meaning of this statement or sentence? The constitution may defend individual dignity even against majority opinion. This is very important. That is called as the societal trap, the trap number one. And we are moving to trap number two, that is the source trap. What is the source trap? Listen carefully. The word morality is mentioned inside the constitution. Is mentioned inside the constitution. For example, Article 19, Article 25, and Article 26. But here comes the trap. The specific doctrine called constitutional morality is not explicitly defined anywhere in the constitution. Please remember this very much carefully. Not explicitly. This is implicitly through Article 19, Article 25, and Article 26. Constitutional morality is not explicitly defined anywhere in the Constitution. It is a judicially evolved doctrine. This distinction is extremely important because UPSC may try statements like this: the term morality is absent from the Constitution, or they may say constitutional morality is explicitly defined in Part 3. Wrong, because it is implicitly, not explicitly. And this is where elimination precision matters. And moving to trap number 3, that is overreach trap. Critics argue that constitutional morality can sometimes lead to judicial overreach. What is judicial overreach and why? Because if judges begin using personal morality instead of constitutional principles, then separation of powers becomes weak. And this debate is extremely relevant for governance questions. Why? Because the core question becomes who decides morality inside a democracy? Society, legislature, judiciary, or constitution? This tension itself is the heart of modern constitutional governance. This changes everything because constitutional morality is not merely legal interpretation, it is institutional survival. That is the thing here, institutional survival. That is the constitution here, that is the constitution morality is here. Now let us see how constitutional morality applies inside actual governance. Please open your test 3B handout, which will be available in Metis IAS Academy Telegram channel. In that, look at the governance and look at the governor related question under Article 200. Please observe very carefully. The issue is, can a governor indefinitely delay assent to a bill? Indefinitely. Technically, the constitution was not completely explicit regarding timeliness, but the Supreme Court's intervention and Supreme Court's interpretation emphasized that as soon as possible. As soon as possible. What? As soon as possible. Silence of law is not equal to power to sabotage democracy. This is not correct. As soon as possible. This is very important exactitude keyword, that is as soon as possible. Emphasized that by Supreme Court's interpretation, the apex court. Now understand the deeper logic here is the governor cannot misuse constitutional silence to defeat the legislative will of an elected assembly. And this is constitutional morality in action. Because constitutional officers are expected to function with restraint, fairness, democratic fidelity, institutional responsibility, not tactical obstruction. This is why constitutional morality is becoming increasingly important in federalism, governor disputes, parliamentary conventions, judicial accountability, and institutional ethics. That is why constitutional morality is becoming increasingly important. And for UPSC, this means one thing. What is this? What is the thing? You must stop studying governance as isolated articles. You must start studying institutional behavior. You must start studying institutional behavior under constitutional pressure. Now imagine UPSC gives this statement like this: constitutional morality refers to prevailing social values accepted by the majority. Most aspirants will mark it correct, but the keyword trap here is majority morality. Constitutional morality may actually protect individuals from majority pressure. The single distinction can save you one mark on May 24th. This will complete the learning loop psychologically. One day, as a district magistrate, you may face a situation like this where the law permits something, but constitutional values reject it. That is when governance stops being mechanical and becomes constitutional. So you have to remember one once the full system here is the institutional restraint, dignity over majoritarianism, spirit over mechanical text, and constitutional limits over personal morality. You have to remember these full system. So remember the final pattern, that is constitutional morality means fidelity to the spirit of the constitution, not merely mechanical obedience to the text. Spirit, spirit of the constitution rather than text. And one day as an administrator you may face situations where the law is technically silent but the constitution is morally screaming. That that is where constitutional morality begins, and that is why for 2026 you should not prepare merely as a student of law or governance or polity. Prepare as a student of the republic. Remember this for May 24th prelims examination. Constitutional morality is not about what society feels. It is about what the Constitution protects even when the society disagrees. That distinction can separate selection from elimination. Attempt the diagnostic quiz on Telegram. Master the spirit and the facts will follow. I will see you at the top. Stay precise and thank you.